I think Gobi's case illustrates the serious breaches and failures in the Singaporean criminal justice system, particularly in relation to the drug trafficking regime that presently exists in Singapore. Now, Gobi is among the very few, an extremely rare case of a person who actually was released after having been on death row and in danger of being executed at any point of time. Now that is rare. Most of the other prisoners who end up in death row end up going through the process, end up being executed, hanged, and that's the end of the matter. And I think it's very significant that Gobi's case, Gobi was only able to escape the gallows because of the ability of lawyers, in this case M. Ravi, to file an application to bring to court a critical legal issue or a severe or a serious flaw in the original conviction and the appeal process, which was a clear miscarriage of justice, right? And the fact that Mr. Ravi was able to move the court and obtain the commutation of the sentence from death to some years of imprisonment was because at that point there was at least some avenue of accessing the courts. Now, his case now illustrates the extreme injustice that prisoners on death row and others who have been charged for under the Misuse of Drugs Act in Singapore are facing. Their access to the courts have been blocked at every turn now, and through legislation which is unknown in the Commonwealth. As far as I know, there is no such legislation. Other countries don't have legislation such as the PACC, such as the strict provisions of under the CPC itself, plus other penalizing provisions, provisions that penalize lawyers and others who bring up or file applications in court in order to either commute the sentence or set aside the conviction. This is very surprising because one would have thought that the state of Singapore or any state would welcome the assistance of anyone, friends, relatives, to file cases and bring any dispute or any potential miscarriage of justice to the attention of courts. Okay, it doesn't matter if many applications like this come before the courts. This is the job of the courts in any country that follows the rule of law. You sift through the applications, you give a fair hearing to anyone who files an application. If there is no merit, you are free to dismiss it. If there is merit, of course, you have to make the correct orders. But somehow this has not been happening in Singapore. Somehow the filing of any application challenging a conviction post the final disposal of all appeals is viewed as some kind of an assault or an attack upon the Singaporean system. So this essentially means that many prisoners are going to die on the gallows even though there has been a miscarriage of justice against them. And Gobi's case illustrates that. Because under the present system, Gobi would have died on the gallows. I have to say this very bluntly. Under the present system, he may not have got past the PACC Act, the new Act, and brought his case to the attention of the judges. So I think right now this is a very serious and ongoing problem now. There are many Malaysians also, and we are very concerned because there are many Malaysians who are still on death row. For some of whom I myself am still acting as the Malaysian solicitor. They have all been subjected to this to the new regime of restricting and confining legislation and other kinds of rules that the Singapore authorities have brought in. I fear that many people are going to die needlessly on the gallows who ought to be released or at least to have their death sentence commuted to a sentence of imprisonment. Yeah, I think the approach of both Malaysia and Singapore, which I think originally, I believe in the 80s, started on the same page, which is both countries decided to come down very hard on drug trafficking, and their method, which was flawed from the beginning, was to go after drug mules and all the little people who are sucked into the chain of the drug trafficking, of the global drug trafficking industry. Okay, and flawed because they were from the beginning they went after mules and those people who are insignificant, whereas the major players in drug trafficking get away with it, you know, and they build they amass huge amounts of wealth. They've got high-rise buildings. We know that. I think the Singapore government also knows that, right? So it was flawed from the beginning. But I think the difference between the Singaporean and the Malaysian approach is that over the years, Malaysia somehow, the Malaysian authorities, Malaysian lawmakers, even those in government seem to have lost the appetite for hanging, for drug cases, you know, and generally lost the appetite for execution as a method of punishment. It has been a very gradual process with stops and starts, with steps forward and steps backward, but in general the direction of things in Malaysia is a lack of appetite for execution as a method of penal punishment, even though that punishment has still been maintained. But from our observation, Singapore has gone the other way. As the years have passed on, they seem to be more bent on execution as a method of punishment and have been very inflexible about it. And I think that is why in Malaysia the mandatory death penalty for drugs and for all other offences actually has been removed, and the discretion has been given back to the judges. Even though death penalty has been maintained in Malaysia, but the discretion has gone back to the judges. And we all know, lawyers know, that when you give the discretion back to the judges, and rightly so, judges are reluctant to pass the sentence of death except in very exceptional cases. And that is exactly how it should be. Whether in India, whether in Malaysia or in India, most Commonwealth countries practice that concept, or the rule that you cannot pass the death sentence if you are still maintaining that sentence except in exceptional circumstances. In Singapore, it's been the opposite. In the most minor case of smuggling of small tiny amounts of drugs, which might be a misdemeanor in Australia, people are being sentenced to death in Singapore. So this seems to be the difference of approach. And of course, I think any right-minded person will say that Malaysia is going in the right direction on this. Although for us lawyers in Malaysia, not even the Malaysian authorities have not gone far enough. We want to see the end of the death penalty in Malaysia. And we feel our government and our country has not gone far enough, and we want that to change. But in comparison to Singapore, certainly it's better, you know. And what we hope is that the Singaporean government comes to realize that you are not stopping drug trafficking by going after people like Gobi and others, or those who are now, you know, languishing in death row. You're not going to solve the problem. Therefore, why have it? Why maintain a form of punishment that is irreversible if you go wrong, if there is a miscarriage of justice, you know, and that doesn't have any utility. It doesn't achieve the object of putting an end or reducing drug trafficking. We know that there has never been, and this has been one of the things that I think most lawyers and anti-death penalty advocates have said it over and over again to governments. There's no evidence that it acts as a deterrent. People who decide to do these things don't check the law books and look at matters that way before they venture into committing these kinds of offences. So it doesn't work. There's no deterrence. There's no empirical evidence that it deters, and yet governments insist. And you have got some ministers, for example, Mr. Shanmugam, who come out very publicly insisting that the death penalty has reduced or has, I don't think even he can say it stopped drug trafficking, but that it has had impact on the on drug trafficking, on reducing drug trafficking in Singapore. But he seems to have no study or no evidence to back up what he's saying. He just says it. He says it's working, you know. In the first place, I think even those studies are flawed studies. The way the questions have been posed, the methodological issues, there's problems with the studies, and I don't think those studies are in any way representative or conclusive of what is the real opinion of Singaporeans or the real opinion of the population, you know. But in any event, we also know for a fact that even in countries that have abolished for many decades, there is always going to be a proportion of the population which prefers to have the death penalty. This is not a reason whether to maintain or abolish the death penalty. The reason to maintain or abolish the death penalty are whether or not it is even achieving your purpose, and whether or not that punishment itself is a punishment that can be maintained in human society in view of the fact that it is brutal, it is irreversible, and it can cause miscarriages of justice, as it has done over and over again in human history. You know, so to say that Singaporeans want it, therefore we proceed is not an answer. You know, the whether they want it itself there's a big question mark there. And secondly, even if they did, this is not something that can be decided by public opinion or mass opinion. There are other factors that need to be taken into account.